Hi, welcome to this episode of Inside View. My name is Cory Burnell, and I'll be our host for this episode. And we're joined by Ethan Turner, our Deputy County Counsel here in Calaveras County. So, Ethan, thank you for joining us.
Sure.
Pleasure to meet you and see you.
You as well.
We're going to be talking about kind of a hot topic. It's made our community here, pretty active, and it's been controversial at times over the last few years. That is the Cannabis Ordinance, commercial cannabis growing, which for our viewers, they should know that you serve in the position of Director of the Division of Cannabis Control. Is that correct?
Yeah, I'm the interim director. I've been doing that since December 21st, and I'm actually leaving the county in about a month. On April 1st, I go to I'm going to work for the state, for the AG's office to work in the Division of Cannabis Control there.
Oh, wow, okay. So yeah, this is something that's really, you were brought here for this specialty when the urgency ordinance was put in place, is that correct?
That's correct, yeah. I came on in September, maybe it was even August of 2016, to work on administrative enforcement issues, administrative adjudication, appeals of cannabis denials. And then I handled the bulk of the lawsuits that were filed against the county during the urgency ordinance and after the ban was enacted.
You know, on that subject, what were some of the topics that brought litigation, or some of the arguments that were made during the urgency ordinance that caused people to file suit?
Every lawsuit that I handled was brought by an aggrieved cultivator who felt that the county had erroneously revoked their cultivation license, or in other circumstances where they felt that we had inappropriately fined them and executed abatement warrants on their properties to eradicate commercial cannabis.
Okay.
So they can bring what's called an administrative writ of mandate to seek review of decisions made by the Planning Commission or the Board of Supervisors or an administrative hearing officer to attempt to overrule the decision made by the county to yank their license or to fine them or otherwise abate cannabis on their property.
Okay. Well, we then had the urgency ordinance expire. And now, just as of last October, the Board of Supervisors passed a permanent commercial cultivation ordinance. Is that correct? It was October of last year?
Yeah, October 22nd. The board passed it, and the fee took effect on December 22nd, and that's when we started taking in applications for the new program. I should point out also that between the expiration of the urgency ordinance, which was enacted in May of 2016. It expired in February of 2018. There was a ban, and during that time, all cultivation was prohibited, even personal outdoor cultivation.
Right. Now, during that ban, there was some cultivation authorized for personal use under the state law. Can you explain what that was and how that was administered?
Well, under the ban, state law allows a local jurisdiction to almost completely ban cultivation of cannabis. The minimum or the most onerous regulations we can put in place is 6 plants indoors or in an accessory building. But a local jurisdiction can completely ban outdoor cultivation.
Okay, and that was the case in our county.
That's right. Yeah.
Okay. Okay. So the effective date here was essentially December 22nd of last year.
That's
for taking applications for commercial growers under the new permanent ordinance. You want to talk a little bit about what qualifies someone to be able to be a commercial grower now?
Yeah. In order to be eligible, there's a couple of different sets of criteria. There's individual eligibility for the business entity or person that wants to apply for the program, and that criteria is that they were in good standing under the urgency ordinance program, and that they applied for a temporary license with the state before June of 2018, and that they either received a temporary license or the temporary license was denied for reasons that were beyond their control, having to do with the ban. Because there was a period where there was confusion between the California Department of Food and Agriculture and our local jurisdiction, where the state didn't realize that even after the ban was implemented, commercial cultivators had 6 months to wind up their businesses. And so many temporary licenses were erroneously denied during that period, and those who had their applications denied erroneously by the state because of the ban are also eligible. They just had to have applied for the temporary license before June of 2018.
Okay.
And then the parcel eligibility is the other one. So there's individual eligibility, and then the land has to be eligible. You have to be zoned a certain set of zones: general agricultural zoning, unclassified zoning, and rural agricultural. But there is no rural residential, and certainly no residential. And your parcel has to be at least 20 acres in size. Under the urgency ordinance, a person could grow up to a half acre of cannabis on a parcel as small as 2 acres in size. And that was part of the reason that there was so much controversy, as you alluded to. Additionally, not only could you grow a half an acre on 2 acres, but you could do it in a rural residential subdivision.
Right.
So there would be rather large commercial cannabis operations on small lots in subdivisions, and it's perfectly understandable why that was upsetting to many people.
Well, sure, I see therein lies their motive for the controversy, right? Now, with as I understand with the permanent ordinance, this 20-acre parcel minimum, that also can only grow half an acre. Is that correct?
No, you can grow a full acre.
A full acre on the 20
for outdoor cultivation.
Yeah.
Mixed light cultivation, you can only grow a half acre on an acre.
Okay.
And you're also allowed to co-locate. So
That's where I was going to go next. Yeah. Co-location.
With co-location, you're allowed to have up to an acre of outdoor cultivation per 20 acres.
Right.
So if you have 100 acres and you can get 5 permits together, so you would have to get either have 5 eligibilities of your own, or you can actually purchase the right to apply to the program. Like, for example, if you had a cultivation license under the urgency ordinance and had a temporary license, you could sell your right to apply to the new program to a third party, and that person could do it. So there's people who actually are purchasing multiple rights to apply. The largest group I know of, one person has aggregated 12 rights to apply. So if that person had 200 acres or 240 acres, they could grow 12 acres of cannabis on that 240 acres.
Right. Now, is that one individual can have those multiple rights to apply, multiple permits?
That's right.
They don't have to go get multiple individuals who each hold one.
No, they can buy certain rights to apply. They can buy rights to apply, and they have to submit a separate application for each right to apply.
Okay.
And the application fee is $12,561.
Okay.
Which is a number we arrived at after doing an exhaustive fee study, and that's just one of many, many expensive fees that a cultivator has to go through in order to.
Yeah, let's talk about that a little bit. Under the urgency ordinance, a permit costs $5,000 at that time. Yeah. Now, when it had expired, growers received refunds because not all of that funding that was raised for the program had been spent, right? So in looking at this fee analysis, you now have fewer permits, which you say was, maybe 195 expected?
Yeah, we anticipate as many as 195, maybe slightly more, because we actually until recently, we did not have a record of all the people who were denied by the state erroneously. Fortunately, through coordination with the California Department of Food and Agriculture, or CDFA, we've gotten their records, and now we can actually cross-reference their records with our own and determine how many people are eligible, and it is roughly around 195 or so.
Okay. Okay. Well, obviously, far fewer permits to spread the cost of administering the program over than I think previously under the urgency ordinance. What you take in something like 700 applications or something?
Yeah, I think it was in the 730s, if I recall correctly.
Yeah, 5,000 a pop's pretty good. Pretty good chunk of change for administering the program. Of course, you had more parcels to to cover at that time.
And also, I would say that Calaveras County employees and the county in general, as it operates, tends to be very. They're very scrupulous about how they spend county resources because they have such a long history of being underfunded, and so there was many things they could have been doing with the funds that would have been proper uses of the funds, which they didn't do, and I think we actually in a sort of after action review of the program, the fee even with 700 some odd growers should have been more like 7,000, and it was due to the way we spent the money, and that resulted in us not spending the full $3.5 million that we took in, and that also partially explains why it took so long. I mean, many of the 700 applicants never made it through to the end of the process.
That's right. Yeah.
So not everyone had their site inspection, and site inspections actually were going on all the way into 2018. And had we staffed up as we really actually needed to handle that load, we would have spent more than the $3.5 million we took in, and should have probably spent something on the order of 7,000 per permit.
Yeah. Yeah, that's a good point. Well, then, all right, so that's the application fee. Other expenses for growers, though, I mean, Measure C is still the law in the county, is it not?
It is, yeah, and Measure C is the commercial cultivation tax, the tax on the privilege of cultivating, and it was a canopy tax.
Yeah.
Cultivators had to pay $2 per square foot, but the way it was written, once the track and trace program goes into effect, which is a program administered by the CDFA to track the cultivation of cannabis from seed to sale, comes into effect, then it was supposed to and is going to convert into a per pound tax. And I don't remember the figures exactly, but yeah, so now we're going to be charging per dry weight pound and per trim. And then, and I don't remember the figures, but it'll result in roughly similar amount of taxes.
Okay. Yeah, I remember that. Yeah, the generalization of that $2 a foot, and with the track and trace, can you speak to the effectiveness of that in other communities where it's being applied? I mean,
not really. A cultivator could probably tell you more about that than I could. Every cultivator is required to have a licensed data entry person on their payroll who enters data into the track and trace program, and they have to go through a training from CDFA, and then they have to track everything. Every plant is tagged. They're weighed when they're cut. It's a tremendous amount of data that they have to continuously collect and transmit to the state.
And that'll be happening this grow season here in 2020 here in Calaveras County?
You can't get a provisional license without enrolling in the track and trace program.
Okay.
So to get a local permit here, you have to have a provisional license from the state. That's one of the baseline requirements. And,
right.
And to get a provisional license, among many other things, you have to be enrolled in the track and trace program.
Well, let's let our viewers know a little bit more about how track and trace works, and that, okay, each plant is tagged. Now, you said from seed all the way through harvest, so, I mean...
To retail sale.
Okay, to retail sale,
yeah. They say seed to sale, but as
yeah.
most people know, that most cannabis plants aren't grown from seed. They're grown from cuttings.
Yeah, clones, yeah. So then, so really you're tagging each plant. You said each plant is weighed at immediately when it's cut, and harvested.
I believe that's correct.
Okay.
I mean, a cultivator would be able to tell you much more, or a CDFA representative would be able to tell you more about that. I don't know the details.
Yeah. Well, do you know what the rates are going to look like, the tax rates per pound? In the
You know,
county?
I don't remember what they are offhand. But anyone can look it up if they go to Muni Code or Google the Calaveras County Code and look at Chapter 3.56.
3.56.
Yeah,
huh?
that's Measure C was codified as Chapter 3.56 of the County Code.
Oh, okay.
So just Google that, and you'll find the tax rate early on in the code.
Yeah. Very interesting. Then, just so viewers, so we have clarity on, okay, the difference between commercial cultivation and, say, dispensaries, for example, in retail sale. Did the permanent ordinance have anything to do with retail sale laws or regulation here in the county?
No, that's governed by Chapter 17.91 of the County Code, which currently only allows for medical retail sale.
Okay.
And it's being updated soon. It's going to go to the Planning Commission, I believe, next month, or at least soon, and it'll be amended to allow for adult use sales.
Interesting.
And retail sales are also taxed in the county at 7% under Chapter 3.56.
Okay. Okay. So with the state law being that recreational adult use being legal, as you mentioned earlier in our discussion, the county can be more restrictive than that. So currently the county is more restrictive and only allows for medical sales?
Yeah, the state, you can get a medical license or an adult use license from the state, and you have to actually specify because for medical use, if you have a prescription, you can get it at 18 years old. And adult use is for 21 and up, it's like alcohol.
Okay.
And the way the state regulatory program functions is that you have to have both a local license or local authorization if there is no local license, and a state license. So it's a two-tiered program. So in 90% of counties in Calaveras County, in California, you can't cultivate, and many jurisdictions have bans on retail as well. And the same with all the other license types. There's many license types you can get from the state for different aspects of the commercial cannabis industry, and each license type has to be allowed in the local jurisdiction.
Yeah. Wow. Okay. So, well, let's talk a little bit about the current challenges, perhaps legal challenges to the new permanent ordinance. I guess it's under fire, is it, in court?
Yeah,
there's been some
it
litigation
is.
going on. What can you tell us about that?
Yeah, an organization called Calaveras Residents Against Commercial Marijuana. The acronym is CRACM.
That they're pro-crack, huh? Anti-marijuana?
I don't know. I'm not sure about that, but
Okay.
they certainly take issue with the way that we adopted our ordinance.
Okay.
They're attacking it on grounds that we violated or that the county violated the California Environmental Quality Act, or CEQA, when we adopted the ordinance. And obviously the county disagrees. The CRACM attempted to get a preliminary injunction against implementation of the ordinance back on February 14th, and the court denied the injunction, and so the program is rolling forward.
Mm-hmm. Well, yeah, what a hiccup that would be for business owners looking to make a capital investment in their business, only to find out that they're not a go for grow season.
So many people waited to apply to the program until after the court denied the request for an injunction.
That would make sense. Okay, so can you speak a little bit about the process for our viewers who aren't familiar with, what do you mean with the CEQA and EIR? An environmental impact report needs to be done in order to determine how this legislation would impact the environment locally, right?
Yes.
And that was done previously, prior to?
Yeah, well, I'm not a CEQA expert, but the long and short of it is the Public Resources Code requires that anytime you do a land use ordinance, you have to assess the environmental impacts of the land use ordinance, and then either adopt mitigating measures or adopt overriding considerations, or select a project alternative, or at least identify project alternatives before you adopt an ordinance. And the urgency ordinance was a land use ordinance, but urgency ordinances are exempt from CEQA. If the Board of Supervisors makes the findings that there's an imminent need based on public health and safety concerns, they can adopt an ordinance quickly. And the justification there was that there was massive environmental degradation occurring as a consequence of black market cultivation that was occurring in the burn scar after the Butte fire. And that so the board adopted urgency regulations to force cultivators to register with the county and comply with a strict set of environmental standards. There's varying opinions on how successful that was, but I think under the circumstances, the county did a pretty good job of mitigating what would have otherwise been an unmitigated total disaster. And during the pendency of the UO, which is what we call the urgency ordinance around here for short, CEQA review was done, and an EIR was published on a regulatory program to follow the UO. However, as everyone or most local residents know, there was a change in the Board of Supervisors as all of that was occurring. And the Board of Supervisors chose to adopt a project alternative, which was no project or a ban. So a ban was a project alternative identified in the original EIR, and then so the county had done the environmental analysis on a regulatory program, and so when the board came to adopt the new ordinance, they relied on the former EIR and adopted an addendum to that EIR to make findings about the changes in the ordinance that were different from the original proposed regulatory program, which had 700 cultivators and 2-acre minimum parcels. So the overall impact of this new program is significantly less than the former program by orders of magnitude. So that's the process in a nutshell. And the Crackham Group and their attorneys feel that an addendum was inappropriate and said so in their complaint. And obviously the county disagrees.
Sure. What the EIR process there, what kind of cost does that have for a program like this? Is it significant?
Yeah, it's massive.
Yeah, millions of dollars? Is it
no, it wouldn't be
hundreds of
millions,
thousands?
but yeah, hundreds of thousands. Yeah.
Okay.
Yeah, it's expensive, as is the litigation.
Sure. Yeah, absolutely. Significant concern, I'm sure, in the community about environmental impact and abuse. I remember seeing various supervisors meetings where, reports and presentations were being made about some of the environmental abuse at different grow sites. But I seem to recall that they were generally illegal grows that type of activity was going on, but I don't know if that's accurate or not.
Oh, I'd say that's. I mean, there were people in that registered with the regulatory program whose cultivation sites were not ideal, and their permits were denied or the registrations were revoked. But it's true that the bulk of the most egregious and terrible environmental harm that occurs is in the black market cultivation sites. Though it is not accurate to say that everyone who enrolled in the UO was a, quote, good grower, as people say. There were a lot of health and safety violations and environmental violations, illegal timber harvest, illegal grading, illegal wastewater discharge, many health and safety violations around employee safety, many issues. And that's why of the 700 or so growers, about 400 of them had their registrations revoked.
Oh, wow.
So it's because the industry could not adjust to the basic regulations of running a business in California.
Sure.
Or follow basic building standards or grading standards. And it caught up to them, and we ended up revoking their licenses. And many of them appealed those, and many of those ended up in subsequent lawsuits.
Yeah. Yeah, which you spoke to earlier. Have you found that the regular, and maybe this is a question for our sheriff, but have you found that it frees up the resources of the county for enforcement against illegal grows by having what you might call responsible participants in the industry who are regulated? Is there any accuracy to that claim?
Yeah, there is. I mean, I think so. During the urgency ordinance, there was unprecedented enforcement that on scale that had never been seen before. In 2017, the sheriff's office did a fantastic job and eradicated an unbelievable number of cultivation sites. The Met team at the time was headed up by a particular sergeant who was very zealous and very good at his job, and also very good at organizing interagency enforcement. And he worked with Fish and Game, with the EPA, the Department of Toxic Substances, and even brought in the National Guard in a series of raids that he called Operation Terminus, where I think he took out something like 23 grow sites in 30 days.
Wow.
It was pretty amazing. And then on the administrative enforcement side, our code compliance team also affected a tremendous amount of enforcement. They issued 227 or 228 in that neighborhood citations for illegal cannabis cultivation. And that happens to be a much cheaper method of enforcement. The sheriff's department at the time in code compliance sort of divided up the workload, with the sheriff taking obviously the riskier cultivation sites that were cartel type grows on public lands, grows that also perhaps could have been sites of meth labs, and code compliance took on the illegal commercial cannabis sites that appeared in the judgment of the Met team. That's the marijuana enforcement team, is the sheriff's team, to be safer, and they divvied up the workload very well, and between the two of them, easily eradicated over 300 sites in 2017, and that was during the pendency of the UO.
Wow, that's fascinating. Do we see any decline in the ability to enforce against illegal grows during the ban? Or was the pace of enforcement able to be kept up? Well,
the pace of enforcement was much slower during the ban, and it's a revenue issue. A criminal search warrant costs a lot of money to execute, and we didn't have the Major C revenues to pay for those. And administrative enforcement, while there's cost recovery mechanisms for that, because when you do administrative enforcement, you treat it like a public nuisance. And when you go to eradicate an illegal commercial cannabis site as a public nuisance, you can actually put a lien on the property to recover the costs of doing the enforcement action, whereas you can't do that with a criminal search warrant. So there's cost recovery mechanisms, but you need the resources to do investigations, patrols, helicopter flights, et cetera. So basically, it's just the equation is it's just a money thing. The more money you have, the more enforcement you can do, and certain activities can be covered by fee funds as well. Administrative enforcement can be paid for through fee funds, whereas criminal enforcement can't, and that's in Article 13 E Section 1 of the California Constitution. I think that's right. That was brought about by Prop 26. That regulates how we can spend fee funds that are brought in for regulatory programs.
Ethan, you are a wealth of information, and I know your time is valuable, and I greatly appreciate you showing up with us tonight and sharing your expertise. We've run out of time. I think you and I could have covered 60 minutes together, you know. Maybe that'll be the name of our next program, 60 Minutes. Thanks for joining us, Ethan. And again, to our viewers, Ethan Turner, our Deputy County Counsel here in Calaveras County. Hope to see you again soon.
Sure. All right. Thanks.
Yep.